Do you hear me? Yeah. Good morning, everybody. On behalf of the organizing NGOs, I welcome you to this side event on the human rights defenders situation in the United Arab Emirates. Just for you to know, to situate the United Arab Emirates in the framework of the UN human rights machinery, the Emirates have acceded to the Convention for the Elimination of Racial Discrimination in 1974, to the Convention on the Right to Child in 1997, to the Convention for the Elimination of all discrimination against women in 2004, to the Convention Against Torture in 2012, and to the optional protocol to the Convention on the Right of the Child on the sale of children, child prostitution, and child pornography in 2016. But the Emirates have not acceded to the major international conventions, meaning the Convention on Economic, Social, and Cultural Rights and the Convention on Civil and Political Rights. In the framework of the Universal Periodic Review, the United Arab Emirates had the last review in January 2013, and next one will be in January next year. And for this, the deadline for the submission of informations for the stakeholders, meaning the civil society, will be next 29th of June. In 2013, already, many NGOs and governments expressed their concern about the situation of human rights defenders in the Emirates. Some recommendations made by governments have been received the support of the authorities of the United Arab Emirates. Today, it will be the occasion to evaluate the situation of the human rights defenders in the Emirates and the situation about freedom of expression, freedom of association. So we will start with Mrs. Joyce Hackme, if I'm correct, yes. Academy Fellow in the International Security Department of Chatham House, the Royal Institute of International Affairs in London, who will speak about the social and legal background and the consequences, in particular, of the adoption of the Federal Decree Law on combating cybercrimes. Please, you have the floor.
Thank you very much, Mr. Fattorini, and it's a pleasure to be here today. I'll be having a PowerPoint presentation, so I don't know where you guys will be looking. I'll try and look at this screen. So my presentation today will be about cybercrime law in the Gulf in general and in the UAE in specific, and I'll be talking about that and kind of like the impact that it has on freedom of expression. So before we start actually like talking about cybercrime and freedom of expression, it's very important to understand what we mean when we say cybercrime and how does the international law basically define cybercrime. There isn't like one definition of what cybercrime actually means. It is rather a collection of offenses categorized under different categories, and obviously one offense could fall under one or more of these categories. So to start with, we have offenses. Cybercrime could include offenses against confidentiality, integrity, and availability of computer data and systems, and that means like anything like hacking, use of malware, the denial of service attacks. For example, what happened recently, like with the WannaCry ransomware attack, that could be categorized under this category. The second one is related to computer-related offenses, so anything that has to do with credit card fraud, computer forgery, etc. The fourth one is copy-related offenses and everything that has to do with that. And the third, which is very much like in relation to what we will be talking about today, is the content-related offenses. And the international law, let's say, or international approach, which is mainly through the Budapest Convention, the main convention on cybercrime, defines this to three main offenses. A, offenses related to child pornography. B, acts of racist and xenophobic nature. And C, hate speech. So we keep this in mind as we kind of like talk about the situation in the UAE and the law in the UAE and the Gulf. So we defined what cybercrime means. What is the role that kind of the cybercrime actually laws play in fighting cybercrime? So they have different roles that basically cybercrime laws play, and there are of extreme importance. So first, obviously, criminalization, prevention, and deterrence. They provide the foundation for successful prosecution and adjudication of cybercrimes. B, they actually play the role of eliminating safe havens. So cyber criminals cannot really roam free from one country to another. So if cyber crimes, for example, these offenses are considered as, these conducts are considered as offenses in this country, they also be considered in other countries as well, and therefore eliminate the safe havens and facilitate international cooperation between the countries, which, as we know, is extremely important because cybercrime is a transnational crime and does not respect the borders. And the third one, which is very much in relation to what we're talking about today, cybercrime laws are very important to balance, actually, to provide the right balance between protecting fundamental rights such as freedom of speech and freedom of privacy, etc., and security. So the laws basically provide this sort, or tries to provide this balance. So what is the problem then in the Gulf and in the UAE as well? So the problem in the Gulf is that, so we talked about like the different 4 categories, right? And with the content-related offenses. In the GCC and in the UAE, the definition of cybercrime on content-related offenses extend to a wide spectrum of acts, as we will see later. So it's not really confined. So they do have in their laws the 4 categories and on content-related, but the content-related, instead of having it just for the 3 that I mentioned before, extend to a big spectrum of acts, as we will see later. And the second issue, this GCC cybercrime laws, and I guess Julia will be talking about this in detail, is the primary function of this law have been to monitor and filter the internet against any content that does not adhere to the political or social sentiment of the region. So how it all started, like what is the background for all of these, for these laws and for this kind of, for the application of these laws? So as you all know very well, the social contract that exists in the GCC between the ruler and the ruled is one where the ruler promises prosperity, order, and freedom to pursue a socially and economically satisfying life in exchange for the acceptance of full states of control of politics. So it's basically like the father taking care of his family, he'll provide for them, and but also he'll be the one who will be making the decisions, etc. And that has been the case throughout the kind of like, even like from the beginning of these states. So, but at the same time, so we've got that in the background, but also the technological developments that happened in the Gulf and the UAE in particular have been extremely impressive. If you look at the table below and the internet users per 100 in the Gulf, we see like we have very, very high numbers, and actually one of the highest numbers in the world. For example, in the UAE, 91.2% out of 100 have access to internet and use social media and so on. So like we talked about the social contract, we talked about the social development. The social contract obviously brings with it like some sort of like social constraints. So you've got with this kind of like a relationship that exists between the ruler and the ruled, you have a limited public sphere for interaction, you have a limited room for political opinion, of course, you have lack of civil society infrastructures, lack of free media, and lack of representative governance systems, because that's how it's normally is when the relationship is governed, as we said before. But this, combined with the technological advances that we said, that I mentioned, the highest, like one of the highest subscription rates of mobile phones in the world, one of the highest and growing internet penetration rates, very high social media use, a very young and tech-savvy generation. The average age in the Gulf is 27. So everyone is connected, everyone is wired, everyone is on social media. So that actually led to what I call like something like a sort of cultural revolution. So on one hand, social media and the internet became like a lifestyle, it created a platform for exchange that did not exist before. It gave a voice for citizens. People started using it as a marketplace, especially for women, for overcoming like the social taboos that existed before. We saw a lot of like increase of like women starting their businesses from from their homes via Instagram or other social media platforms. So it had like a very impressive impact on the society and states as well. So it wasn't just confined to citizens. States as well started using it for started using social media for positive PR and for their image and for advertising their plans and so on and so forth. But it wasn't just limited to that, obviously. With the Arab uprisings that were taking place, social media also started being used for political ends as well. It started being used, the social media platforms actually replaced physical demonstrations to the point where some people started referring to Twitter as the UAE's Tahrir Square. So it became like a very kind of like the platform where people actually could voice their opinions, could contribute to the political situations, could actually start, engaging more and more with their government and with their rulers. So basically that wasn't a situation that the governments could predict or contain. So that put them in a very, very delicate situation. And I argue that basically these kind of all of these elements and of course much more contributed to the creation and to the enactment of cybercrime laws in the Gulf and in the UAE as well. And if we look at the timeline of when these actually laws were implemented. So we had the uprising starting in Tunisia in 2010, and then afterwards we see like Oman enacted its anti-cybercrime law in 2011. The UAE abrogated its previous law of 2006 and introduced a new one in 2012, which basically added offenses related, to IT, like the stuff that we talked about before in terms of phishing and hacking, but also it added offenses related to anything that affects or threatens state security and promotes terrorism, which many of which were already included in the existing UAE media law of 1980, but have now been basically updated for online activities. And basically, the content of these laws had nothing new per se. They all existed, similarly to the UAE, they all existed in previous laws of media and publication. But as I said before, they updated these offenses to everything that has to do with online activities. So yes, so UAE enacted its law in 2012. Bahrain inaugurated the Cyber Safety Directorate, which assumes the role of monitoring websites and social media networks, and enacted its cybercrime law. Qatar followed suit in 2014, Kuwait as well, and the Saudi, which is always kind of particular case when it comes to the legislation, is looking into updating its cybercrime law. So without going into very much details, in terms of a legal structure of the law, but any law, in order for it to be fit for purpose, has to have, and any cybercrime law, in order to be fit for purpose and to fight the cybercrimes as we've defined them, the content-related, but also the other categories, has to have these different categories. So it has to define, the terms that they're using, has to define the offenses that are considered, that are criminalized, procedural powers, who does what, the electronic evidence, which are, of course, of utmost importance to any cybercrime investigation, has to define the jurisdiction of the law, international cooperation, as I mentioned before, which is very important for fighting cybercrime. Countries need to talk to each other, need to exchange intelligence, need to exchange evidence. So the law needs to elaborate on that, and also has to elaborate on service provider liability and responsibility. But as we see, all the GCC laws, and the UAE in specific, they focus on definitions and criminalizations. Nothing on procedural laws, nothing on electronic evidence, nothing on jurisdiction, nothing on international cooperation, et cetera, et cetera. So the main purpose of the law, if you look at it from that lens, is basically this is what we mean, and these are the contexts that are considered as offenses, and these are the sanctions. So that is basically the meat of the law. Now, if we move to the kind of the substance of these laws, and remember when I said the problem, the dilemma with the Gulf and with the UAE is that the cybercrime definition extends to a very wide spectrum of acts. These acts, for example, I mean, first of all, let's look at the table. We see that Bahrain has nothing, in its law that relates to these provisions, and that because they have these provisions already in their penal law. But then also the Cyber Safety Director plays the role of monitoring the internet. But the law in itself is is kind of on that level, is similar to the, let's say, the UK law or to the Budapest Convention, etc. But if we look also a little bit more in details, we see that the UAE law has the most articles that actually consider the offenses as cybercrime, such as obviously offending, insulting the ruler, his family, or a public official, damaging national unity and security, foreign policy, public ethics, social values, defamation and slander, overthrowing the ruling regime, changing the system that always has the highest sanctions in any GCC law, damaging state reputation or ruling family, spreading false news which damage the reputation of the country, retweeting, participating and supporting in an unlawful group, invasion of privacy, publishing news, electronic photos, etc., even if they are true and correct. So we can see, this table I've put all these provisions and kind of try to see in each law which articles actually tackle these particular provisions. So you see the scope to which the definition of cybercrime extends in the Gulf. So what is the problem with these things, and what is the impact on freedom of expression? So, as we said, expanding the definition of cybercrime to a very, very wide range of offenses. The second, and that is really the most important thing, is that all of these laws, and the UAE law as well, they have broad and vaguely worded provisions. And by having that, basically, they do not allow people to kind of regulate their behaviors. We know, laws have to be very, very precise. So as citizens, we understand that this is, an okay behavior. This is not an okay behavior, so we avoid it. But with that, it's very difficult to do that because, it's the provisions are very broad, they're very vaguely worded, so basically anything could constitute an offense under these laws. And because they are like that, they grant the government extensive powers to punish anyone who publishes content that do not adhere to the social and political sentiments of the country, as I mentioned before. And fourth, obviously, the impact on freedom of expression, it gives people this chilling effect on your right to freedom of speech, and you start exercising some sort of self-censorship, whether you're an expat, especially if you're an expat, you don't want to be deported the next day, or for citizens, you say, I don't want to get into trouble, so let's not say anything at all. So it has this it's been having actually the self-censorship impact. And of course, it has severe, and this, all of these lead to severe restrictions on the rights to freedom of speech and freedom of association and assembly, and also allow the country to facilitate arbitrary crackdown on peaceful dissent. And as Gianfranco mentioned, the UAE is not party to any, main, not party to the ICCPR, not party to the main conventions on human rights, but it's also, in its constitution, it has, it protects freedom of speech, freedom of assembly. It's also, part of the Arab Charter of Human Rights, which has also, the kind of protection of freedom of speech, etc., and so on and so forth. So on that note, I'm going to stop and leave it to Julia to talk more about the implementation, and I'll be happy to take any questions at the end. Thank you very much.
I thank you, Mr. Ahmed, for this very interesting presentation on the social and legal background about the situation on freedom of expression. Mm-hmm. And I'm sure there will be many questions about it. And now I will give the floor to Mrs. Legner, who will present maybe some more concrete cases that happened in the United Arab Emirates. Please, you have the floor.
Thank you very much. Yes, I'll be speaking a little bit more about the human rights violations that we've documented under these laws, the cybercrime law, the anti-terrorism law, and the new amendments to the penal code. So over the recent years, we've seen a clear deterioration in the human rights situation in the United Arab Emirates. As a human rights organization documenting cases of enforced disappearance, arbitrary detention, and torture. Al-Karama has documented dozens of cases of lawyers, teachers, human rights defenders, and anyone critical to the authorities, merely for really making use of their right, their fundamental right to freedom of expression, peaceful assembly, and association. So usually it's the state security forces that are under the control of the Ministry of Interior, and they're not subjected to any legal oversight, which are responsible for the arrest of an individual. And we then witness a series of chain violations, usually starting with an arrest of someone without an arrest warrant or informing them of the reasons for their arrest. They're then being held in solitary confinement or secret detention for prolonged periods of time without access to a lawyer or access to their families. And this time they're then often subjected to acts of torture in order to extract confessions that can later be used at court against them. In particular, human rights defenders are often tried before the State Security Chamber of the Federal Supreme Court, which is known for gross violations of fair trial guarantees. And as mentioned before, the tools that are used to crack down on activists and human rights defenders are usually the law or the anti-terrorism law, which also provides an extremely broad definition of terrorism, the cybercrime law, which criminalizes defamation and slander and provides for harsh prison sentences of up to life imprisonment for anyone who establishes, manages, or runs a website or publishes information aiming or calling to overthrow or just to change the regime. And recently also we've seen the amendment of the criminal code or the penal code, which now has even more provisions that severely curtail the right to freedom of expression. And so as we've seen, the independent expert and former special reporter on the independence of judges and lawyers, Ms. Gabriela Knaul, has visited the UAE on an official visit in 2014 and afterwards expressed her great concern regarding incommunicado detention and the use of torture in the United Arab Emirates. She stated that even though the criminal code or procedure code prescribes the need for an arrest warrant, many people are arrested without a warrant, and particularly in cases of national security. Regarding the work of lawyers, she said that an accused person often has very restricted access to a lawyer, and again that applies mostly in situations of state security crimes, and even the lawyers encounter difficulties in accessing their clients' files, and many of the hearings are not being held in public. Furthermore, some lawyers that are taking up state security cases have even themselves been harassed, threatened, and pressured and been considered disloyal to the state. What we've seen in the most recent times, just another example of a crackdown on freedom of expression in relation to the Gulf crisis, has been when the UAE Attorney General announced that the expression of sympathy towards Qatar could actually be punished with 3 to 15 years of imprisonment or a monetary fine, whether that is on social media platform or via any written or spoken medium, and this will also be prosecuted under the cybercrime law. So now, after a bit of a general background, I would like to talk to you about some of the cases that are very emblematic of the lack of freedom of expression in the UAE. I would like to start with the case of the UAE 94. So in March 2013, we've seen the largest political trial in history in the United Arab Emirates, again before the Federal Supreme Court of Abu Dhabi. 95 people, of which 8 were tried in absentia, were prosecuted for wanting to overthrow the regime, a charge they consistently denied, and that is punishable with up to 15 years of imprisonment under Article 180 of the Penal Code. The majority of the accused were then sentenced to from 7 to 10 years of imprisonment. And among the victims, we have prominent lawyers and human rights defenders known for their peaceful activism. And even the lawyer that worked on the case has been arrested for defending them. Because of their political action and commitment to defend human rights, these people suffered long periods of incommunicado detention, and some of them were subjected to severe acts of torture. The UN Working Group on Arbitrary Detention actually issued an opinion in which it considered the deprivation of liberty of 61 of the individuals in that case arbitrary. It states that the UAE government has a duty to release these detainees and provide them with adequate reparation. Moreover, the opinion stated that the detention clearly results from the exercise of their right to freedom of opinion and expression and to freedom of peaceful assembly and association, and that expressing criticism of one's country in a peaceful way should not be categorized as an attempt to overthrow a government. To date, these individuals are still detained. Another case is that of Osama Najjar, who's a prominent Emirati blogger, who was also arrested in March 2014 for defending his father, who was actually one of the accused in the 94 trial. He was denied access to a lawyer for 6 months, and he was accused of belonging to a government-banned party and instigating hatred against the state via Twitter, and designing and running a website harmful to the UAE institutions, offenses that clearly fall within the cybercrime law. And he was in the end sentenced to 3 years imprisonment and a fine of $136 US. And the court also ordered that all of his social media accounts and his website be closed. Now, on March 17th of this year, after serving his full 3-year prison term, he should have actually been released. Yet the public prosecution decided to extend his detention, arguing that he still poses a threat to society. The court accepted the demand and ordered the transfer to a counseling center. According to Article 40 of the Federal Law on Combating Terrorist Offenses, which prescribes that if a person appears to pose a terrorist threat, he or she shall be sent to a counseling center. Well, that's very problematic because he clearly is not a terrorist but a blogger. He has served his full prison term. This is an administrative detention that we're seeing now. It's not actually a judicial decision. There's no chance for him to legally challenge this decision. I'd also like to talk about the case of Nasser bin Raith, economist, academic, and activist, who was sentenced to 10 years imprisonment in March 2017 under the UAE Penal Code, the cybercrime law, and the law on countering terrorism because of a series of tweets he had published on his personal account. So on the 18th of August 2015, he was arrested by the state security officers, taken to an unknown location. He was then disappeared for 8 months before he reappeared in front of the Supreme Court. He has stated that he was tortured and held in solitary confinement, yet the judge decided to ignore his allegations. This is also not the first time that Nasser bin Raith was prosecuted for being outspoken or expressing his opinion. In 2011, in a case that we know as the UAE 5, he was already prosecuted with 4 other activists, among them Ahmed Mansour, and he was arrested and sentenced to 3 years imprisonment for having openly called for economic and democratic reforms. So now the last and the most recent case of human rights defender Ahmed Mansour. I think among the human rights community, we know that he was really one of the last human rights defenders still operating from within the UAE. He's a close, dear friend of ours. He was a close source, and he's been prosecuted before, and now he's faced again reprisals for the work that he did. When on the 20th of March 2017, state security officers raided his house and confiscated his computer and cell phones, They then took him to an unknown location where he's currently being held, incommunicado, not allowed to access a lawyer, at the moment also not allowed to contact his family. 2 weeks after his arrest, on the 3rd of April, his family was allowed one short visit when the authorities moved him from where he was held to the prosecutor's office in Abu Dhabi. So to date, there's no news on him. He's not under the control of the law. He's not been given his legal guarantees. And 2 weeks after his, a few days after his arrest, actually, the special reporter on freedom of peaceful assembly and association, the special reporter on freedom of opinion and expression, and the special reporter on human rights defenders urged the UAE government to immediately release human rights defender Ahmed Mansour. After contacting the authorities, the experts stated in a joint press release that they regard Mr. Mansour's arrest and detention as a direct attack on the legitimate work of human rights defenders in the UAE, and that Mr. Mansour's outstanding work and the protection of human rights and the advancement of democracy, as well as his transparent collaboration with the UN mechanism, is of great value not only for the UAE but for the whole region, and that they feared that his arrest and secret detention may constitute an act of reprisals for his engagement with the UN human rights mechanisms, for the views he expressed on social media, including Twitter, as well as for being an active member of international human rights organizations. And the press release of these special reporters ended on a more general note, summarizing the situation in the UAE that is of great concern, not just to non-governmental organizations, but to the UN as a whole. And it reads as follows. The UN rights experts are also urging the Emirati authorities to end the harassment and intimidation of human rights defenders in the UAE and to respect the right of everyone to freedom of opinion and expression, including on social media and the internet. Thank you. I'll be happy to answer any questions.
I thank you, Mrs. Legner, for presenting these concrete cases, and here too, I'm sure there will be some questions, also in relation to the implementation of the law against terrorism and the linkages with the cyber crimes law. Now we will have a presentation through Skype of Mr. Ahmed Al-Nuaimi, Emirati human rights defenders.
Assalamu alaikum.
Here we are.
Can you hear me?
Yes.
Okay, shall I start?
Yes.
Hello, everyone, and good morning. I don't know if it's good afternoon now in Geneva, sorry. Thank you for having this time for the UAE, the human rights in the UAE, and thank you for giving me this time to tell you about the facts, what is happening in the UAE now in the human rights. Actually, I am a citizen of the UAE who is very sorry to talk about the human rights in the UAE. The place that I love, the place that I grow up in, the place that I love to see all the people live in peace. But unfortunately, as we know, that this country, which is sometimes it's hope for a lot of people to live in, it's face a really great problem that we have to focus on. What I want to talk about today, actually, it is about the people who are in the prison now and their family and how they face a lot of violence because of their opinions. last year, in the same time, we had the same conference, almost the same conference, and we had Ahmed Mansour, the activists from the United Arab Emirates. Most of you know him. We had him as a speaker by the Skype. Unfortunately, nowadays and today, we don't see him. We can't contact him. We can't know anything about him because he's in the prison, and no one can reach him except his wife sometimes can know something about him, and she saw him once maybe. This problem occurred in 2012 when they arrested people for the petitions that it's written in the UAE. Most of the people who are in the prisons, they signed that petition. From that day, we see a lot of violence come in the UAE, and the people who are in jail face a lot of harassment in Arizin jail. Let me focus on one story, which is Imran's story. And that story started last month. During the last month, several violations to the prisoners' rights took place in Arizin prison, in which all the prisoners of serve their imprisonment in a very bad condition. One example of that is that what happened on the 25th of May last month, when the Nepali guards forced the prisoners of some chambers, like chamber 7, to take off all their clothes and give them only a small towels to cover their sensitive parts of their body and facing the wall. This wasn't the end of the story, but they started to then they started searching in a humiliating way with sexual harassment and touching their sensitive parts. All the prisoners were shocked and refused their harassment, and among them was Imran al-Ridwan, who decided since then, the 25th of May, to go in open hunger strike to protest against such humiliating treatment, and calling to sue all the people who committed this crime against the prisoners of Al-Razin. Now, Imran al-Ridwan is now he is entering the day. Now he's entering the day number 20 in his continuation hunger strike. In his continuous hunger strike, he lost over 9 kilograms from his weight, and he is suffering from spasmodic jerks and cannot stand. He is in a very serious condition that requires immediate action. As his family saw him last time, he had no balance to walk, and he can't even stand up. This one example that happened last month, and it's continuous now. And every month we hear a lot of stories from the families, and the families who are banned from traveling, and some of them are banned from having jobs, and some of them are banned from study. We see every day a lot of violence happened there. I don't know how long we have to wait to see that change, but the people there are suffered. And we know Muhammad al-Rukn, who is in a prison, who get a lot of rewards last years, the latest years, and we saw there is no action, unfortunately. What is happening? This prison now is under the control of the security authority, and it's play great part in that place, and no one of the people in the prison can even complain. Whoever complain, he can can face harassment, he can face violence in the prison, and no one can hear his voice. So nowadays we see that the human rights violence increased, and people lose more and more from their human rights. And unfortunately, we see even the media machine work against all that people. Lately, we had a documentary which was in the channel TV of the UAE. We saw how actually they lied, and they give a lot of lies about the people who are in the prisons and the people who were in that trial. They build a lot of stories about them. So we know this problem will not end if the authority there will not listen for the human right voice. We hope, like this conference, can make difference, can make change in the human rights in the UAE. Thank you very much.
I thank you, Mr. Al-Nuaimi, for his presentation. Unfortunately, we cannot communicate directly with him, and I don't know if any question can be addressed to him by phone or WhatsApp, maybe. We have some 15 minutes for a Q&A session, and maybe I will take advantage of my position as moderator to raise the first question to Mrs. Ahmed. You spoke about the vague wording and definitions in the law of the Emirates, and I would like to ask you if there is any specificity compared to other law about cyber crimes, especially with countries from the south of the world, or even African or South American countries.
Yeah, thank you for your question. You do find some similarities in, like, for example, countries like Pakistan, for example, where they also have, they criminalize, conduct such as, like, defamation and slander. They consider them as cybercrime, and they do have vaguely worded provisions in their laws. But normally, cybercrime laws do not actually extend to cover these areas, so you don't find these kind of, like, vague provisions in, like, normally in cybercrime laws. But the interesting thing is that if you look, for example, at the surveillance laws in, let's say, either the UK or the Netherlands or Germany, etc., they also adopt this approach in terms of some vague worded provisions in terms of what it means to be, like, what constitutes as a threat to national security. And they've been criticized by human rights organizations for not providing enough safeguards for, protecting the rights to privacy and the rights to freedom of whatever expression or assembly. So why the GCC, I think, is a particular case. The adoption of vague worded provision is not, just particular to that region generally. It is so for cybercrime, more or less, but we see the kind of similar pattern in different laws in different countries.
Okay, thank you very much. Thank you very much. And a question to you, Mrs. Legner, about the relationship between cybercrimes law and the law against terrorism, how it is implemented in the country.
Well, from what we've seen in the documentation of cases is really that the cybercrime law is a bit of an extension to some other legal instruments that existed beforehand. So like in the law on terrorism or in the penal code, we have issues that relate to state security or national security, and then again there are very vague provisions on what constitutes a threat to the regime or the state, or what could harm the reputation of the state, which is already sort of existent in these laws, and then is also again criminalized when, let's say, voiced on Twitter, social media, websites, and so on, and criminalized through the cybercrime law. Yeah, that's what we've seen.
Thank you very much. I'm sure there are many questions in the room, so please raise your hand and introduce yourself. Please.
My name is Fresh Finish. I'm a former UN staff. No, my question is about dialogue. Is there any contact, any dialogue between NGOs, human rights defenders in the Emirates and NGOs here with the authorities? Is there any kind of contact and dialogue to have some common understanding of what we can do to improve the human rights situation in the Emirates? Thank you.
Maybe I'll answer to that or give some insight into the experience that we've made. I mean, as part of civil society, I think in general we would be very open to be in touch with the authorities, to see to understand their perspective, and to find a way to maybe enhance the human rights situations from both sides. However, the experience that we've made with the UAE shows that so far has not bared any fruits or has not been very successful. We also see that, I mean, we usually communicate cases of human rights violations to the UN human rights mechanisms, which also give the state a possibility to answer to allegations. And what we've seen a lot in the past is that the authorities were reluctant to provide any answers. And when they provide answers, they're insufficient, or they're basically denying allegations. And that has so far not really given us the opportunity to engage productively in a dialogue with the authorities. Yet I would like to say that we're very open to that, or me personally. Yeah.
Any other question? Maybe I will raise another question to both of the panelists. As I said in my introduction, the United Arab Emirates in 2013, at the end of the exercise of the Universal Periodic Review, they did support some recommendations about freedom of association and freedom of expression and the protection of human rights defenders. And my question is, have you seen any improvement since 2013 in this field?
Yeah, no, it's an interesting time at the moment because, as you said, the next Universal Periodic Review is sort of just coming up, and that's the time to reflect back on the recommendations that were made and to see which ones were implemented, which ones weren't. And I mean, if we look already at the recommendations made during the last UPR, you said that there were some that were regarding association, freedom of association and freedom of expression that were accepted, yet if we look more closely into detail, only very vague provisions on generally promoting and protecting the right to freedom of expression will be accepted, and none of the recommendations, for example, with regards to acceding to the ICCPR or the CAT or any other really major human rights instruments were accepted. So we kind of see a bit of a reluctance there to really step up the game and yeah, I mean, follow those very essential conventions.
Well, I'd actually comment from the cybercrime law perspective. We recently had a workshop in Dubai where we were talking about the cybercrime laws and their impact on the digital economy in the Gulf in general and the UAE in specific. And we had officials around the table, and they actually were telling us that they are now in the process of reviewing their law. Because we were talking, it was mainly focused on digital economy and how, because they've been investing a lot in trying to diversify their economy beyond past the oil era. And so they've been investing a lot in smart infrastructure and digital economy and in creating this kind of progressive platforms for the economy and also for governance. And so one of the recurring issues were cybercrime laws have been used actually for a different kind of focus. And one of the responses we got was that they're looking into reviewing their law. Now, whether they review it to enhance the situation or to make it worse, that is yet to see. But I guess for me, I always find it very fascinating how the UAE has been, Maria here, their organization work on basically addressing the issues of how the UAE has been investing quite a lot in in its image abroad, right? In terms whether in their engagements in sports or in other activities, and they've been really very keen on having a good image of progressive country. They recently launched the Ministry of Tolerance, the Ministry of Happiness. So they've been kind of trying to show to the world that a different face from what normally people in this room talk about. Now, whether this would lead to actually concrete impacts and whether this will enhance the human rights situation, that is yet to see. But I believe personally that it's very difficult to maintain the situation. On one hand, promoting this very progressive discourse, while on the other hand, having a situation of very difficult human rights conditions.
Thank you very much. Yeah, you want to add something?
I think also that goes back to that question we've heard before in terms of the interaction with the authorities. What we would really like to see as well in the beginning, or what could also help the whole process, is more active interaction with the UN. As I've said, the experience that we've made is that often the response to individual cases and individual allegations of human rights violations are not responded to in a sufficient manner. And also, for the treaty that it has ratified, the CAT recently, the authorities are late 3 years in submitting their report. And when it comes to visits of special reporters that would be relevant, such as freedom of expression, peaceful assembly, human rights defenders, we would also welcome to see some proactiveness by the government to really cooperate with the UN. Thank you.
Thank you very much. Any other question?
Everything was so clear.
No? Then we will finish with 2-3 minutes left. But I thank you very much for your participation and attention, and I thank you, the panelists, for their presentations. Thank you very much to everyone.